KRAMER, which served on the faculty of the University of Pennsylvania School of Medicine and the Children's Cancer Research Center of the Children's Hospital of Philadelphia until 1984. She conducted research into the epidemiology and etiology of childhood cancer, taught epidemiology methods, and has served as an epidemiological expert witness in state and federal courts in over 30 cases as a plaintiff's expert. She is co-author of the IAC Ethics Guidelines for Environmental Epidemiologists. According to Dr. KRAMER, the participation of epidemiologists as expert witness is critical to our mission. She will expand on this topic and also examine the problems posed by the combative modus operandi in the courtroom, and the title of her presentation is Taking Sides in the Courtroom, the Epidemiologist as Expert and Advocate. Dr. Sheila KRAMER.
Thank you. And thank you for the invitation to speak today. I'd like to set the stage for my talk. You are an expert witness testifying on behalf of plaintiffs and about to be deposed by the attorneys for the defendant companies. Now imagine walking into a room where there are at least 50 attorneys representing the defendant companies and 50 more participating remotely. There are 3 cameras focused on you recording the proceedings, a cluster of microphones in front of you, a huge stack of documents on the table, and many boxes of additional documents to be produced by the attorneys questioning you. Rapid-fire questioning, which quickly jumps from one subject to another, one document to another, and largely consists of out-of-context statements and questions which are framed primarily as yes-no answers or agree-disagree responses, are aimed at producing short, incriminating sound bites that can be used to try to disqualify you as an expert or can be played back to the jury in court to weaken your testimony. And this goes on for several days. Do you think this is a prescription for a balanced discussion of scientific evidence? Well, now I'd like to take you back with me this morning to 1991, to the very first case in which I was asked to serve as an expert witness. I came into my office one morning, and amidst papers spewing out of my fax machine, I received a call from a private investigator, which took me by surprise, to say the least. The investigator was working on a case involving extremely high exposures to coal tar and its constituents in a small town, and 4 cases of neuroblastoma that occurred in this community, coincident with the exposure scenario. And this exposure scenario was truly shocking. An open pit of coal tar the size of a football field was left open for 2 years right next to the town's playground and athletic fields. The backstory included cover-ups by the company involved, air monitoring data that not so mysteriously disappeared, uncalibrated equipment, and irresponsible behavior on the part of the local and state public health agencies. However, despite all that we know about the carcinogenicity of coal tar, there were actually no studies in the literature that directly linked the specific type of exposure to coal tar to this specific outcome, pediatric neuroblastoma. Would I get involved? Should I get involved? The courtroom is a very alien world for most epidemiologists. It certainly was for me. But it's an important world that we should understand because it can drive policy, it can create public awareness, it can influence corporate practices, and it may be the only avenue for compensation to individuals who have been harmed. At this point, I should note that I've only testified in cases in the US, and therefore my comments and perspective aren't necessarily applicable to systems in other parts of the world. In full disclosure, I've testified on behalf of plaintiffs in over 30 cases, with the defendants often being large companies, and many of these cases involving large numbers of plaintiffs. So if there is bias in my viewpoints, it's a reflection of this deliberately chosen path and one that's not balanced in terms of testifying on behalf of both plaintiffs versus defendants. So the title of my talk today is Taking Sides in the Courtroom, the Epidemiologist as Expert and Advocate. Let's start with the actual label expert witness. Epidemiologists are engaged by either plaintiffs or defendants to provide expert testimony about causation. And this testimony about causation is fundamental, and it's a fundamental aspect of environmental and other types of tort litigation. When we think of a scientific expert, we might envision a professional who's deeply knowledgeable about a subject and who would present a complete and balanced exposition of the facts supporting their opinion. And this is what we're accustomed to in discussions of topics relating to causation among colleagues, at meetings, and in publications. Furthermore, it takes us a long time to even get to an opinion about causation. Epidemiologists are generally reticent to make declarative statements that X is a cause of Y, and it often takes decades of research to get there. We're accustomed to asserting that there's always more information needed, coupled with the fact that the flow of funding would greatly diminish if the question were settled. However, as an expert witness in litigation, this construct does not apply. In sworn testimony, the expert witness must take sides and become an unwavering advocate for that side. This advocacy doesn't leave much space for acknowledgement of weaknesses or other possible explanations. Expert opinions that are expressed aren't through dispassionate, balanced discussion. They're highly assertive and definitive. The win or lose environment of the courtroom is combative, and any doubt, skepticism, or chinks in the armor will be attacked and exploited by the opposition. And this is the environment in which we must articulate complex scientific and methodological concepts in a setting with real-life implications. So, what are the factors that create this position of advocacy in the courtroom? To begin with, the outcome is binary, win or lose. Each side has a huge amount at stake and will fight for its point of view, utilizing every strategy and tactic available. And the expert is a key participant in this fight. Advocacy is also shaped by the expert's worldview and philosophical viewpoints. What is our professional role in ensuring the protection of public health, and what are our ethical and moral values relating to corporate behavior and accountability? Moral outrage, in fact, a deep emotional response, is a promoter of advocacy, where the facts of the case are often egregious and show deliberate and harmful wrongdoing on the part of the defendants. Another challenge is that judges and jurors often lack the training to evaluate the technical aspects of the evidence and can therefore be swayed by misrepresented epidemiological principles or other factors that have nothing to do with the evidence itself, such as perceptions about the character of the expert witness, which is always a target in these cases, the expert's demeanor, the expert's dress and academic credentials, and so forth. An incident that stands out for me is a time when a judge, in the middle of my testimony in court, suddenly banged his gavel, raised his voice, and demanded to know, how could I question the opinion of someone from Harvard? And finally, there's the human effect. Serving as an expert witness can bring you face to face with individuals who've suffered a loss or been injured or harmed. And the presence of these individuals in the courtroom can have a profound effect on the expert. A further complication in reconciling the objective expert and courtroom advocate roles is the standard by which the scientist must judge the evidence for causation. The scientist is asked to render an opinion to a reasonable degree of scientific certainty, which meets a more probable than not, that is, 51% standard. But what does this actually mean? We haven't been trained to think along these lines, and there's no clear definition of this threshold. Often the science is incomplete. There's a lack of studies that focus on the specific exposures and outcomes in the case, and it's necessary to extrapolate and connect the dots, so to speak. I might think that the 51% threshold is met, while another epidemiologist might not, based on the same set of evidence. So I'd like to go back to my experience in that first large case for which I served as a causation expert as a means of highlighting these contrasts and these ethical issues and the opportunity that I've seen for positive impact. Recall that the issue was exposure to very high concentrations of coal tar and coal tar-related constituents. 4 cases of neuroblastoma occurred within 2 years in the community of Taylorville, Illinois. Neuroblastoma is a rare peripheral nervous system cancer affecting infants and young children. In a community the size of Taylorville, statistically, only one case in 29 years would be expected to occur. Sadly, one of the children died very shortly after diagnosis, and another child was left paralyzed. The law firm contacted me because I had previously published a study that showed an association between neuroblastoma and coal tar-containing hair dyes. Using a population-based pediatric tumor registry, our case control study found a 3-fold elevated odds of neuroblastoma associated with maternal use of coal tar hair dyes during pregnancy compared to randomly sampled controls. This study was the only direct link reported in the literature of the specific relationship between neuroblastoma risk and coal tar exposure in humans. And here are the factors that had to do with the reckless actions on the part of the defendant utility company, the lack of accountability of public officials, and the total disregard for the public's health that influenced my motivation to participate. The defendant, a large public utility that had been the owner of a former manufactured gas plant site, had caused extensive environmental contamination and exposure in the community to liquid coal tar, particularly in and adjacent to the public park and playground. In fact, while they were fighting with regulators over the extent of required remediation, the environmental engineering company that the defendant hired had left an open pit of coal tar the size of a football field right next to the playground for 2 years. Exposure to the community was further exacerbated during the drawn-out period of remediation of the site because of uncontrolled emissions and coal tar-laden dusts that were blowing off of the site and the uncovered trucks that tracked the contaminated soil through the neighborhoods, as well as the open pit of coal tar. Remediation workers and nearby residents and park visitors reported strong odors, headaches, nausea, and several of the residents living closest to the site were hospitalized for symptoms of acute exposure. This photograph, and let's see if I can find yes. So this photograph shows, this is the containment building over this open pit of coal tar. This photo was taken years later, right next to the playground and playing fields, and these homes were just adjacent to it. You can see that this white containment building which contained the original pit, was very, very close to the playground and the residences. And as I reviewed the details of the case, I was stunned by the irresponsible behavior of the company, by the dishonesty and cover-up on the part of the firms responsible for the remediation, and by the state public health agencies, whose behavior was more protective of the company than the public's health. The utility had taken advantage of a business-friendly voluntary cleanup approach without the cost and controls of the U.S. CERCLA requirements which govern the remediation of Superfund sites. In fact, they had been forewarned by an environmental engineer who had performed air dispersion modeling about the likely risk of excess cancers if they proceeded with their plan to excavate the site with backhoes and no control over emissions. The first question was whether I could testify as to general causation in this case. That is, could I say that it was more likely than not that exposure to coal tar could be a cause of neuroblastoma in the children of Taylorville? The epidemiological and toxicological literature strongly supported the multi-organ carcinogenicity of coal tar, its constituents, and contaminants at the site, such as PAHs, nitrosamines, VOCs, and particulate matter. In fact, recognition of the carcinogenicity of coal tar goes back to 1775 in the famous studies of Sir Percival Pott, who showed that coal tar-related soot caused scrotal cancer among chimney sweeps. The literature specific to neuroblastoma, however, was less complete. Several case control studies had linked neuroblastoma to parental occupational exposure to PAHs and dusts, and animal studies showed that mice exposed to nitrosamines developed neuroblastoma. However, the only epidemiological study that specifically evaluated the risk of neuroblastoma and exposure to coal tar was the study that I had conducted. Though the means of exposure, coal tar-containing hair dyes, obviously differed considerably from the exposure circumstances in Taylorville. And this example illustrates a common issue in toxic tort cases involving rare outcomes: the lack of epidemiological studies directly focused on the specific exposures and the specific and rare outcome in this case was neuroblastoma. In an academic setting or peer-reviewed publication, would many scientists be willing to state that coal tar causes neuroblastoma in humans based on these data and the limited number of studies that directly linked coal tar exposure to neuroblastoma? This exemplifies some of the important differences between the academic practice of epidemiology, so to speak, and the legal world, where science is not complete, where the threshold is more probable than not, and where the exposure scenarios are often unique or unusual. So, utilizing a weight of the evidence approach, and in the context of the different parameters that guide decision-making in the courtroom, that is greater than 50%, I was comfortable drawing a general causation conclusion that contaminants from the site could cause neuroblastoma. The second goal was to determine whether or not the Taylorville community was actually experiencing excess rates of neuroblastoma, and if exposures from the site could be a cause of plaintiff's cancers. And here again, I experienced deep frustration at the public health agency that was ostensibly responsible for protecting the public. In order to gain access to the state's population-based cancer registry data, I had to participate in a 3-year court battle with the Illinois Department of Health, for which they were eventually held in contempt of court for repeatedly refusing to release the cancer registry data for analysis. But my analysis showed that the risk of neuroblastoma in Taylorville was 16 times higher than expected, compared to 4 comparison groups, including demographically similar zip codes, both containing and not containing other gas plant sites, the entire state of Illinois, and the US SEER data, with a 1 in 10,000 probability that these findings were due to random variation. There was a combination of considerations that led to my opinion that the contaminants emanating from the site and remediation activities were the proximate cause of the plaintiff's cancers. That is, the highly exposed and highly susceptible population, fetuses and children, the unusual and extremely high levels of exposure in this community, the established potent multi-organ carcinogenicity of the agents despite the dearth of studies of neuroblastoma specifically, the proven completed exposure pathways, and the statistically significant and highly elevated standardized incidence ratio analysis results. The combative and lengthy process involved being deposed by the defense on 4 separate occasions and multiple days of testimony in a trial that lasted 4 months. In presenting my opinion to the court, it was necessary for me to educate the judge and the jury about epidemiological principles, the available evidence, and in particular, to make the case for acceptability of extrapolating from the robust epidemiological and toxicological data on multi-organ carcinogenicity, since no studies existed that examined both the specific exposure and the specific outcome in the case. Experts for the defense argued that this opinion was unreliable and inadmissible because no studies directly linked coal tar and neuroblastoma, and that extrapolation was not generally accepted in the scientific community. But the judge accepted the argument that extrapolation is acceptable and utilized in the scientific community when the data on a specific cause-effect relationship are limited, and that the exercise of extrapolation affects the weight of the evidence rather than its admissibility. So this ruling actually set some legal precedent for relaxing the standard of proof of causation in toxic tort cases where science has yet to thoroughly study a specific rare disease. However, in my experience, I should note that this has not always been the case. The jury returned a verdict in favor of the plaintiffs, finding the company liable for negligence and public nuisance. The defendants appealed all the way to the Illinois Supreme Court, where a panel of 7 justices upheld the trial court's decision in favor of the plaintiffs. Including the multiple appeals, this was a roughly 10-year legal battle. And there were larger impacts of this case. These judgments and the liability faced by the defendant changed the way that the utilities subsequently remediated coal gas sites elsewhere, such that after this case, remediation took place under air containment domes. However, I should point out there are still approximately 52,000 former manufactured gas plant sites in the US and many thousands more around the world, which continue to pose an unrecognized risk to the public. Disturbance of these sites can lead to sudden and intense exposure to toxic and carcinogenic components through multiple environmental media. And I'd like to point out, unfortunately, that since the initial filing of the lawsuit with the 4 original plaintiffs, there were at least 2 additional neuroblastoma cases that were diagnosed within Taylorville, and several of these affected children have since passed away. So while this case was successful, the community certainly continued suffering adverse consequences. Now, my own involvement in this case spanned more than 6 years. And although I've had a very busy career outside of this work as an expert witness, and despite being time-consuming, stressful, and I would say even professionally risky, I made the decision to remain involved in these types of cases because I think we have an important role to play in an impactful arena. I've served as an expert witness in numerous toxic tort litigation cases over the past 25 years. And these cases have all been compelling, both from a scientific point of view, a public health point of view, and a personal point of view. When the physician for a large semiconductor company tells pregnant women that it's safe for them to work in semiconductor fabrication, one of the most chemical-intensive and dangerous occupations, and the company will not honor requests to be transferred to another department, I think this is wrong. When a coal company builds a coal silo 300 feet from an elementary school, which severely contaminates the elementary school with coal dust, and children are getting sick, I think this is wrong. When a community which has had their entire water system contaminated has to fight with the company responsible for the contamination for appropriate and long-term filtration of their drinking water, I think this is wrong. Now, let me be very clear. The science must dictate the causation analysis. The science must be the basis of the causation opinion. It cannot be emotion. But this is the nexus between the scientific expert and the courtroom advocate. Yes, I experience anger and even outrage at these terrible injustices, which for me is a call to action. These experiences have reinforced many of the things that I learned in the Taylorville case. Unusual exposure and outcome scenarios, which should serve as a beacon for further study, rather than be dismissed as a chance event. For example, despite the tens of thousands of manufactured gas plant sites in the US and around the world, there is an absence of studies in the literature relating to the health risks associated with these sites. Epidemiologists are needed to serve as testifying experts who will be willing to take professional risks and support positions that may be viewed by some as unsettled in the scientific community, but for which sufficient evidence exists to make a case in the legal arena, and which are important for the protection of public health. Ethical issues around the need to be an advocate and win the case become particularly salient when you consider the many opportunities to obfuscate, confuse, and misapply epidemiological concepts. Considerable work could be and should be done by our profession to prepare and train epidemiologists to more effectively serve as expert witnesses and to establish professional standards and position papers on epidemiological principles that can prevent abuses in the courtroom. This could be carried out by academic institutions or authoritative bodies such as professional societies or the International Joint Policy Committee of the Societies of Epidemiology. I'd like to end by echoing the advice of Sir Austin Bradford Hill, which is so very relevant to this discussion today. Just because scientific work is incomplete, that does not confer upon us the freedom to ignore what we know or to fail to act when needed. I urge those of you here today to use your experience, your training, and your worldview to bring about positive change working within the legal arena to promote justice and policies which are supportive of the public's health. And I'd like to
Thank you very much, Dr. KRAMER. The last slide was gone, and you are acknowledging the work of your co-work, and so
yes.
We share this. We are with you. Thank you. Now, if there are maybe 1, 2 brief questions. Okay, please.
Thank you, SHIRA, and thank you for acknowledging the International Joint Policy Committee for Societies of Epidemiology, which I chair. Relevant to that, we have 19 societies, epidemiology societies, that are part of our group, but one of the larger US-based epidemiology societies refused to be involved because they are of the opposite view of yours. So I want to see your insight on that, that epidemiologists should not be involved in policy and not be advocates. I want to get your insight on what could be a justification, ethical or not. And I want to end with a comment for everyone. Steve Wing is the unsung hero who have done so much expert witness pro bono for communities, is suffering from terminal cancer, colon cancer, stage 4. And he was given the Integrity Award by ISEE. And I would really appreciate, I think, if everyone can post support. There's a Post Hope website, and under Steve Wing, I think, I just read today that the chemo is failing, and I think even while he's taking chemotherapy, he's supporting the communities as an expert witness.
Yes, absolutely. And Steve Wing is certainly in our thoughts today, and a tremendous example. I certainly wouldn't want to dictate my values to others, but I hold the personal opinion that the field of epidemiology has been too disconnected from actionable policy, and it's frustrating, and it has been frustrating for me, especially since the playing field, in my opinion, is not level, and so much of the valuable and important work that epidemiologists do on the research side is either obstructed or held up by battles in the courtroom. And so I believe that the field needs to take a more direct approach and apply more resources into the policy aspect of our work.